Hello. You I'm supposed to talk? I can't.
Court hasn't started yet, so just chill out.
Huh?
Now just mute yourself until court starts.
Good afternoon, everyone.
Good afternoon.
Good afternoon, Your Honor.
Good afternoon.
All right, we'll get ready to start the calendar. We're going to begin our Fulton County State Court Expedited Accusations calendar. I'm Judge Regina Mensing. This is a calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon thereafter, or after their arrest, the Fulton County Solicitor General's office has already accused the cases of the offenses brought against them, and the case has been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge, so we're able to address several matters, including bond, possible arraignment, and consideration of a possible plea offer if one has been made by the state at this juncture. I'm going to begin by advising everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube. And what is our SAP reset date?
The SAP reset date will be June 6th.
Okay, June 6th. All right. I want to also remind the defendants on this calendar that you have certain constitutional rights. The first being that you have a right to have an attorney to represent you at this proceeding. And at this juncture, most of you should know who your attorneys are by now. You also have a constitutional right to remain silent. Remember that anything that you state about the facts, the circumstances, and the occurrences of your case can and will be used against you at a later date. This is not your trial. This is a bond hearing. So please listen to your attorneys and act accordingly. All right, who do we have first, deputies?
Possession 3, Mr. Key.
All right. All right, this is case number 23CR002737C. Is it Terrell? Did you say it was Ely? Charged with one count of battery, family violence, offense date 9/25/2022. Pretrial.
This is Key, right? Number 3?
I have ELEY.
Key, K-E-Y.
Your Honor, Max Shard here. I represent Takai Key. If that's
All right,
the
hold
case
on
we do.
one second. Make sure I'm looking at the right calendar, but I believe,
Yeah, don't have no Ely.
no?
No. This is an add-on. The Key is charged with battery, family violence.
All right, I'm sorry, 23CR003256A. Mr. Key, charged at one count of battery, family violence. All right, in the same date, 5/22/2023. Apologize for that. Go ahead, pretrial.
Second arrest. Last was back in November. Driving on suspended council registration.
All right, state.
Yes, Your Honor. This incident happened May 22nd, so yesterday, at 405 Fairburn Road Southwest at approximately 2 a.m. Mackenzie Giles, who is the girlfriend of the defendant and who lives with the defendant, stated that they were at a music studio and an argument ensued over Giles following a man on Instagram. At the studio, the defendant grabbed Miss Giles roughly by the shirt, and Miss Giles tried to call 911 for help. The defendant then took her phone and threw it over the fence, breaking it. When they arrived back at the residence at Fairburn Road, the defendant entered to Miss Mackenzie Giles entered to get her belongings and leave. The defendant then refused her entry and grabbed her by the upper body and shirt collar. Miss Giles stated that she grabbed the defendant's phone and ran off in an attempt to call the police. And the defendant followed her, pushed her to the ground, which resulted in abrasions to her forearm and hand, which were observed by the officers. Miss Giles and the defendant are parents of a 1-year-old child, and Miss Giles did relate to the officers that there is a history of incidents between her and the defendant where he has hit her, but she has hit him, but there is only one person who receives an injury during those incidents, which is Miss Giles. She also stated that she has never called the police before this incident date. I will state that we did have an opportunity to speak with Ms. Giles. She stated that it is the defendant's residence and she does not live there, so we are not going to request a stay away order from that address. She also did confirm the events in the warrants and the police report and stated she sustained a swollen finger, scratches and bruises on her hands and knees, and she did in fact confirm that the defendant has been violent with her in the past. That's being said, she does want to continue contact. However, the state does object to further contact between both the defendant and Ms. Giles due to the fact that Ms. Giles herself reported there had been previous incidents between the two of them. So the state does have some serious concerns about a risk of reoffense here, where there's an opportunity for there to be continuing incidents that could prove harmful to either the defendant or Ms. Giles. For that reason, the state is recommending a $3,000 surety bond. We are also asking for no further contact with Mackenzie Giles, 1 day anger awareness, no alcohol, drugs, or weapons. And as they do share a 1-year-old child, we are agreeable to third-party transfer. We would like to at this time sound for Miss Mackenzie Giles.
I made sure Mackenzie Giles is here, and she is here.
All right, where's Miss Mackenzie Giles? Where are you on? All right, I see.
I'm right here. I'm
All
right
right,
here.
would you like to address the court today?
I can't. Are you guys saying no contact with him at all?
Hold on a second. I asked you a question. Would you like to address the court today?
Yes, ma'am.
And if you do, I'm going to swear you in first before you give any testimony, okay?
Yes, ma'am.
All right, raise your right hand, and I'm going to need to see you in order to speak with you. All right. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. Are you in fear of Mr. Key?
No, ma'am.
All right, and would you like contact with him?
Yes, ma'am.
All right, and is there anything else you'd like to tell the court?
No, ma'am.
All right, any cross-examination by the state?
Yes,
No,
Your
ma'am.
Honor.
Hold on.
No,
Your
ma'am.
Honor, if I may, thank you.
Okay.
Miss Giles, good afternoon.
Hi, good afternoon.
Is it correct you told the police and our victim advocate that this is not the first time
Your Honor, I'm going to object to this. This is not trial, and we made that clear in the beginning, and that's not appropriate for a bond hearing.
If I may respond, Your Honor, it's absolutely
Yes.
appropriate for a bond hearing. The Ayala factors go to a risk of reoffense. What better than to talk about any previous incidents between the two parties to allow the court to determine if there is a valid risk of reoffense here?
Okay,
All
but
right.
she didn't even ask that question. She asked if, isn't it true that she said something in the past? A basic foundation for a prior inconsistent statement hasn't even been laid for first.
It's
I'm
clear
not
from
sure if
information.
it's
I
a-
can ask her about whether there have
No,
been
that's-
incidents in the past.
That's
Mr.
not
Key,
how you.
I would let Ms. Judge Mincy say if I'm allowed to ask this question or not you.
And I believe that she's not trying, I don't know, again, trying to establish a prior inconsistent statement. She was asking her about other incidents between the parties, and that does go to my Ayala factors that I'm weighing. And so I will allow that question to go forward. I believe that where she was going was what she stated to the police in the police report or the incident report. And that is allowed at the bond hearing.
And Your Honor, respectfully, she's asking about a prior inconsistency. She's asking about a prior statement. She wants to ask about what Miss Mackenzie Giles has to say now. If Your Honor would like to hear that, that would be one thing. But to ask about what was said in an out-of-court statement, that would be hearsay and inappropriate at this time, in my estimation. That's my objection.
All right, your objection is so noted, but she can ask her about what she stated previously in the police report or to the police per the incident report. Go ahead, Deputy Falk.
Thank you, Your Honor. Ms. Giles, is it correct that you have spoken with our office and with the police and informed them that there have been incidents between you and Mr. Key before?
Yes, ma'am.
And those incidents were incidents of violence, is that correct?
Yes, ma'am.
And approximately how many times have those incidents happened?
Just 2.
Okay, and what was the time frame with those 2 incidents?
One was in I don't remember actually. because it hasn't happened in a long time since it just happened.
Okay. And is it correct that you attempted to call 911 not once, but twice during this incident yesterday?
Yes.
And that Mr. Mr. Key prevented you from calling 911 on both of those occasions?
Yes.
Your Honor, that's all for the state.
All right, any cross-examination? Is it Shart? I don't want to
Yes, Your
mispronounce.
Honor. Yes, Your Honor. I do have a couple questions. Ms. Giles, how you doing today?
I'm doing good.
All right, that's good. I represent Mr. Key.
Yeah.
So am I believe that the district attorney, the solicitor in their recitation of facts about conversations that you had previously indicated that these episodes of violence involved both of you as aggressors and as victims. Is that correct?
Yes, ma'am. I mean, yes, sir.
Okay. And you have, regarding the bond conditions, you have a place to stay that is not with Mr. Key, correct?
Yes, sir.
And if the judge instructed you to spend nights at your other addresses, which is with your mother, would that be something that you would abide by and be able to do?
Yes, sir.
Okay. That's all I have. Thank you.
Okay, thank you.
All right. All right, Mr. Shart, you can, if the state is finished with their presentation, you can go ahead and proceed.
Thank you, Your Honor. May it please the court. Mr. Key, you've heard he has one prior driving arrest, nothing else. He's a high school graduate. He was born in Atlanta, lives on Fairburn Road. I will tell Your Honor, and just to let the pretrial know if they become involved, he does plan to move to Buckhead. So he has a change of address in the works, but it is going to be in the area. He is employed, he is gainfully employed, and he has a 1-year-old daughter with Ms. Giles. As Your Honor heard, Ms. Giles, they've been in a relationship for some time. They are both 18 years old, I believe. They have a child in common. They co-parent, and as far as I understand, they still have a relationship. Ms. Giles does not fear Mr. Key, and she wishes to have further contact. Obviously, neither of them wish to have violent contact in the future, but she does wish to have contact and continue to co-parent their child. She has her own place to live with her mother. So we would ask Your Honor to consider a signature bond with a no violent contact provision that would allow them to spend time together as is their wish, and continue to operate as a family for the good of their young child, who Mr. Key is very involved in the child's life. Thank you, Your Honor.
All right. Did you state he was 18?
I believe both individuals are 18, both Ms. Giles and Mr. Key.
All right. I'm going to order a $3,000 surety bond. I'm going to order that there be no drugs, alcohol, weapons, or guns while on bond. I'm going to order, because this just happened less than 24 hours almost, that there be no further contact at this time, so that we make sure there's been the ample cooling down period. I'm going to order, if there's to be visitation with the 1-year-old child, that be facilitated by a third party. So that, again, there's no violations of the bond conditions. And since the victim has stated that she will be living somewhere else, I will not order a stay away from the location at 405 Fairburn Road, since that appears to be the defendant's residence at the time, at the present anyway. And so that's what I'll order at this point. I'm not going to order anything else, but I think until there's a bond modification, at this point, we will have no further contact with the victim. And I believe that's it. Anything else, counsel?
Your Honor, I know this case is being reset to SAP. What is the date of the reset?
I think she said June 6th.
Thank you, Your Honor. Nothing further for the state.
All right, thank you.
In your Honor,
Yes.
I'm a little new to the procedures with this court system regarding the misdemeanors. Do we need to address anything involving the accusation today as far as any sort of arraignment or anything like that?
No, we do not. If he bonds out, then there will be that note, that further notice. But if he does not bond out, he will be brought back on June 6th. That is our state all-purpose reset date.
Okay, very
If he
good.
has not bonded out before June 6th.
All right, thank you very much.
All right, thank you. All right.
Position number-
deputies. I'm
I'm
sorry,
sorry.
go ahead.
Position number 4 is next.
Okay. All right, this is 23 CR 003257G, Elise Logan, in charge of 1 count of battery family violence. The offense date is May 22nd, 2023.
Third arrest.
Trial.
Third arrest. Last was 08, affray and obstruction. And the 04 shoplifting, first offender.
All right. Jay?
Yes, Your Honor. This incident happened again yesterday at 57 Hardwick Street. Carlos Glenn, who's 14 years of age, stated that his mother, the defendant, had come home from work and began yelling about cigar smoke in the home. The defendant then went to her room, came out, and accused Mr. Glenn of taking 4 quarters out of her money jar. Mr. Glenn denied taking the money, and then the defendant tried to put him out of her home. Again, I will repeat, this is a 14-year-old she was trying to evict from her home. At that point, the defendant began throwing his property out of the home. Mr. Glenn stepped in between her and his belongings in an attempt to stop her from continuing to throw his belongings out of the home. And the defendant began grabbing and pushing him out of the way. Officers, when they arrived, did observe a scratch on Mr. Glenn's cheek, as well as multiple scratches to his torso and arms. And the defendant admitted to police to pushing Carlos Glenn out of the way while trying to throw his property out of the home. At that point, the defendant was placed under arrest. Mr. Glenn was picked up by his godmother, and Miss Logan's 2 children were placed with her sister, where they, I believe, are at this time. There are 2 prior cycles, that 2004 theft by shoplifting and 2008 obstruction out of Clayton. Our greatest concern here is, 1, if there is going to be a defects plan in place for the protection of Mr. Glenn. Again, he is 14 years of age. And 2, as far as we are concerned, we don't want there to be any further violent contact between the parties. I understand that Miss Logan is the mother of Mr. Glenn, but we do have some concerns, being how this was handled, especially with the child of the age of 14 trying to kick him out of your home and evict him. It is problematic, to say the least. Where is he going to go at 14 years old? So the state is asking for a $3,000 surety bond. We are agreeable to no further violent contact with Carlos Glenn, no alcohol, drugs, or weapons, 1-day anger awareness. And we would ask that if there is a defects plan in place, that all parties comply with any orders of defects. That's all for the state.
All right. PD Wills?
Good afternoon,
Okay.
Your Honor.
Good afternoon.
My client is 36 years old. She is originally from Georgia. She does have a high school diploma and is currently employed as a service technician for Grease Monkey. She's been employed there since 2018. She will qualify for our services. My client denies any allegations that she was attempting to evict her 14-year-old. My client states that her child is a juvenile delinquent. He has several open cases and pending cases throughout the metro Atlanta area. He's currently on probation. My client has made attempts to curtail his behavior. However, he is simply out of control. My client asserts that she came home, her child did steal from her, and she believes that he was smoking in her home. She did become upset and asked him to leave the residence. He is not he is currently not at the home. However, my client states that she is the mother of 4 children total. And Ms. Logan states that the other 3 children in the home are actually fearful of her son due to his out of control behavior. And none of his relatives are willing to take him in either due to his behavior. My client has very limited history. She has no violent history. I would ask for a signature on bond in this case. This is a passionate situation. My client's very frustrated with her son's behavior. And she will go through the proper channels to assist herself and her son, hopefully with getting the help that they both need. But again, I'm going to ask for a signature on bond, Your Honor. We're in agreement with the no further violent contact. However, I will leave it at that. And my client would have no objection if DFACS is involved to abiding by any of the terms and conditions that they have put in place.
All right. And I will sound for the victim. I don't know if he's on the Zoom court call. Mr. Carlos Glenn, or anyone with Mr. Glenn. All right. I will order a $3,000 signature bond through pretrial per judge. I will order a no further violent contact with the victim, Carlos Glenn. I will also order that the defendant should abide by any DFACS orders or instructions regarding this child. I am going to order no drugs, alcohol, weapons, or guns while on bond. And I'm going to order the 1-day anger awareness course through pretrial. Anything else, counsel?
No, Your Honor.
All right, thank you.
And nothing from the state, Your Honor.
All right, thank you.
Position 5, Mr. Moreland.
This is 23 CR 003258G. Mr. Moreland charged with 1 count of possession of a pistol or revolver by a person under the age of 18. Offense date May 17, 2023. Pretrial.
It's his first adult arrest. I think he got some open juvie. He went to felony earlier and got a $3,000 or $4,000 good bond for entering auto.
Okay. State.
So, Your Honor, this defendant, who was 17 years old at the time, was on social media posing with a mini Draco AK-47 rifle. The defendant had been...
Oh,
Excuse me. Ms. Carter,
yes, I'm sorry.
can you mute yourself, please? Thank you.
The defendant was previously arrested in 2021 with a Glock 9mm in his possession. He has also been arrested, as pretrials just stated, for entering auto. The defendant reached out to Brett Pinion, who's the deputy over juvenile court, and the defendant has an extensive history as far as his juvenile court convictions are concerned. His most recent was on April 27th, 2022 for theft by taking. He was committed to DJJ on June 3rd, 2021 for possession of a handgun under 18, entering auto, obstruction of law enforcement officer. September 18th, 2020, adjudicated delinquent for armed robbery, hijacking a motor vehicle, burglary, possession of a firearm during commission of a felony. And he was on that theft by taking in April of 2022, he was recommitted to the Department of Juvenile Justice. So the issue that we have here is and granted, under 1511-703, we are permitted to talk about his juvenile history, and I'm talking about it particularly to emphasize how often this defendant has been arrested with guns. There is at least two prior cases, 2021 and 2020, where there has been a weapon utilized in the commission of a crime. So this is a pervasive problem with this defendant. He has an extensive history. Unfortunately, he just happened to get to the age where he is now in adult court dealing with the adult consequences. And so for those reasons, the state is asking for a $20,000 surety bond. We're asking for no firearms whatsoever. He needs to surrender any firearms he has in his possession to the Fulton County Sheriff's Office, We're asking for no alcohol, drugs, or weapons. Again, we do have serious concerns. This is an AK-47 rifle. That is not a gun that, quite frankly, the state feels comfortable being in someone's hands who is of an age where they cannot appreciate this, much less someone with the history that Mr. Moreland has. That's all for the state.
All right. PD Wills?
Thank you, Judge. As it was stated, my client is just 17 years old. He's only been 17 for about 10 days now. In speaking with him, he did say that he understands that his mistakes, that he is hoping to get himself back on track. And so we had a little bit of a conversation about that. He is intending to attend summer school this upcoming summer at Mays. And so with all of that said, I would like the court to take in consideration my client's very young age. He is still basically a child. On the phone is his grandmother and I believe his father. I believe they put that in the chat. And so I did have the opportunity to speak with his grandmother, Miss Deborah Brown. She stated that she would be willing to come and pick him up. So if the court would like to hear from her, she is on the call, Your Honor.
We have on the call the grandmother, who is Deborah, and I'm looking to see, I don't see.
She is under Miss Tanisha Carter, but his grandmother's name is Deborah Brown.
All right. Miss Brown. Still being muted.
Can you hear me now?
I can.
Hey, how you doing, ma'am?
I'm fine. How are you today, Miss Brown?
I'm doing pretty good.
All right. You are the grandmother to the defendant, Mr. Moreland?
Yes, ma'am, I am.
All right. And will he be residing with you?
Yes, ma'am, he will be.
Has he resided with you before?
Yes, all his life.
Okay. All right. And I meant to swear you in, so I apologize. But I don't know how much more I would need from you except for those questions that I've asked. And I usually will ask if there's someone that's involved in the incident, but you obviously were not involved in this incident. Is that correct?
No, ma'am.
Okay. All right. Anything else that you'd like to say to the court?
My main concern is just like I have in counseling when he left YDC and finished up there on the 5th of May. For him, you know, he's finna get back in school and everything. He wanted to get his GED, his diploma, and getting counseling for him because obviously something is happening with his mind for him to, you know, even be on there with guns or whatever, you know, but I don't even go on there because I don't know how to go on Instagram or anything, but he don't give me any problems out.
Let me ask you this. Is he on track to graduate or he needs to go to summer school this summer in order to graduate?
He gonna have to catch up.
Okay, so he would not be graduating next year?
No, ma'am, unless he get everything caught up.
Okay, so that tells me he's not been going to school?
Well, no, he was gone, and every time he went, then he went to juvenile, and then he go back to school, and they never, you know, transcripts and things is all messed up, you know. But okay. I know he can pick up on his lesson right off because he's a smart kid, you know. It's just that he need to be grounded, and I know he needs some counseling. And that's what his counselor came by yesterday and took him to get his transcript and was working on him with a job. But school is more important to me than a job with him right now.
All right, thank you. Deputy Falk, do you have any cross-examination? If you do, I'll swear in the witness. I apologize. Did not do that.
Just briefly, and I'm not sure if it requires swearing in, it was just a general question. Ms.
All right.
Carter, if I may ask, has your grandson, I believe you said grandson, yes?
Yes, ma'am.
Has he been under your care? How long has he been under your care? Let me just ask that way.
On paper ever since he was 5 years old.
And you say on paper,
But me having custody of him.
okay. So he's been under your custody and care since 5 years old, including the times where he's been arrested for hijacking a motor vehicle, armed robbery, and possession of a firearm.
No, he was staying with his dad at the time. And then just like lots of those cases that he had, he speak guilty to him just to get out of jail instead of, just telling the truth, he thought, just saying yes about something he could get out, and I have seen lots of people do that at lots of times, but.
So when did he stop being under your care, under your residence, and start going into his dad's house?
Okay, well, he got all this ever since he been in high school. He stayed with his dad, come to my house today, but I have custody of him.
Okay. Your Honor, that's all for the state. I would also ask, as part of our state's recommendation, that there be a curfew from 8 p.m. to 6 a.m.
That's fine. I like that.
And
right.
Your Honor, speaking with my client, he did share that through his probation, he was placed in various group homes or different facilities, which did cause some incongruity with his schooling and education, which also kind of put him behind a bit. So that's why he was hoping to go to summer school, so that he could get caught up on his credit. So he's hoping to enter into his senior year this fall.
All right. All right, if there's nothing else, you can mute yourself, Ms. Brown, and thank you for your time.
Thank you.
Thank you.
All right. I'm going to render my order now. I'm going to order the $20,000 surety bond. I'm going to order no drugs, alcohol, weapons, or guns while on bond. And if there are any guns, Mr. Moreland, in your possession or in and around you that you have possession of, you need to turn them over immediately to the Fulton County Sheriff's Department. I'm going to order that you go to school or work on getting your GED. So if you make bond and you're out, then you need to be in school or getting your GED, taking those courses. I'm going to order the curfew from 8 p.m. to 6 a.m. I'm going to also well, I don't think I have to order anything else besides the surety bond and the curfew and the conditions of no weapons, drugs or alcohol while you're on bond. But I think that's all I will order at this time. Anything else, counsel, that I've omitted?
Nothing further from the state, Your Honor.
No, Your Honor.
Okay.
Excuse me, Your Honor.
Yes.
His grandmother would like to say one more thing, if you allow her to, please.
Yes, ma'am.
I would like to know how much is it that I have to pay for him to get out on bond?
You have to go through a bonding company and they will tell you that percentage or amount that they will require for his bond. I don't like to state that because I'm not the bonding company or give that advice, but they will tell you once you contact them what that amount will be. Because if I put it out there, you'll say the judge said X amount. So I don't try to mention that amount. But once you contact a bonding company, they'll be able to tell you.
So you said $20,000 surety bond?
It's a $20,000 surety bond.
Yes, ma'am. Thank you for your time.
All right, thank you. All right, deputies.
Position number 1.
This is 23 CR 003254B. Anaya Bailey, charged with 1 count of simple battery, family violence, offense date 5/22/2023. Pretrial,
First arrest, she's 17 years old.
17, okay. All right, state.
Yes, Your Honor. This incident happened on May 22nd, 2023 at 9 p.m. at 7555 Jumpers Trail in Fairburn. Rashida Milanez, the mother of the defendant, reported that the defendant had asked to get her hair done. Ms. Milanez declined due to the defendant's bad behavior. The defendant became upset, left, and later returned. Ms. Milanez would not allow the defendant into the house as she was still being irate and aggressive. The defendant then rammed her body with the door, causing it to swing open and strike Ms. Milanez. She then began hitting her repeatedly in the back of the head. The defendant did with Ms. Milanez. The defendant then went upstairs, police arrived, and the defendant was later arrested. Ms. Milanez's daughter, Anaya Bailey, attempted to record the defendant's behavior, but the defendant began throwing items at her as well. In fact, when the officer arrived, he arrested her at the end of the interaction because she refused to obey his lawful commands and tried to leave the house. So we have had an opportunity to speak with Ms. Milanez. She stated this is not the first time the defendant has been violent with her. This is not the first time police have been called. She stated that this is the first time that the defendant has been arrested. And quite frankly, it appeared as though that the officer was attempting to de-escalate things when Ms. Milanez just refused to follow his direction and tried to leave. She further stated that there may be some issues that would require a BHET. And she finally said that the defendant can stay with her aunt, Darnetta Stone, once she is released, because she is not ready for her to come back into the home as of yet. She does still want contact. I will say the defendant has no history and she is 17 years of age. At this time, the state would recommend and the state is kind of torn on this because we do have some concerns regarding a potential BHET issue. So for right now, the state would offer a $1,500 surety bond through pretrial, with a cosigner, not through pretrial. No further violent contact with Miss Rashida Milanez. Stay away from 7555 Jumpers Trail in Fairburn. 1 day anger awareness. We are requesting a curfew from 9 p.m. to 6 a.m. No alcohol, drugs, or weapons. And I would like to sound for Miss Milanez.
All right. Miss Milanez. Anyone on the call associated with this case or Miss Milanez? All right, PD Wills.
Thank you, Judge. As it was stated, my client.
Can you guys hear me?
All right, are you Miss Milanez?
It's Millines. I'm sorry, I couldn't unmute it first.
Okay, in order to speak today, I have to be able to see you.
I'm trying to figure out how to do this. Can you?
All right,
Can you
I
hear
can
me
see
now?
you now. I can hear and
Okay.
see you. And tell me your
Yes.
last name again.
Millines.
Spell that.
Millines.
INES.
Millines.
Okay, and it's pronounced Millines.
Yes.
All right. Do you wish to address to the court today, ma'am?
Yes, I was just going to say.
Hold on a second. Hold on a second. I want to swear you in. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right. What would you like to state?
I was just going to state, as far as going to my sister's home, I recommended that just as a day or two to also have Anaya cool off, but I am her primary caregiver. There's no other, help. And my daughter does need, I already have a referral for a psych eval from her pediatrician, and that was in the works. But unfortunately, this happened first. So I'm her caregiver. I don't care if she comes home, but it has to be under those conditions, as you stated, with the drugs, the curfew, and no violence. She's more than welcome to come home, but we have to get her the help that she needs.
All right. Thank you. Any cross-examination, Deputy Falk?
No, Your Honor.
Any cross-examination, PD Wills?
No, Judge.
All right. I want to make sure that there's been the proper cooling off period and that we won't have any more incidences.
And Your Honor,
So
if I may make my argument.
I'm sorry. I apologize. I'm
That's
sorry. Go ahead, PD Wills. I apologize.
My client is originally from the state of Georgia. She's currently in the 11th grade and attends Langston Hughes High School. She stated that she does argue with her mother often, and she does wish to reside with her aunt at this time, Miss Dorica Stone. And so we would request a one-time law enforcement escort. We do understand that Miss Bailey technically, for the purposes of caregiving, she technically is still of an age where her mother is still required to provide care for her. My client states that the incident, or she denies the allegations as alleged, and reports that she was both hit by both her mother and her sister on this date. So I would request, just given my client's age, and just the nature of the charges, a signature on bond. We also will be in agreement with a no further violent contact, and we would object to the BHET at this time. And that is all, Your Honor.
All right. Is the aunt's name, I have two different spell. I have a Darnetta, Dorica.
Darnita.
Spell that.
Darneta.
Last name Stone.
Yes.
All right. And you've spoken to her about this situation?
Yes, I spoke with her when I left my work meeting this afternoon, and she stated that there's nowhere for her to, like, she wouldn't have her own space. She would have to share a room with my niece, and my sister also works in healthcare. I work night shift. My sister works weekends, 7 A to 7 P, and my niece is at my house with me every weekend. So,
well, I want to make sure that there is there's been the ample cooling down period for this situation or this incident, and that we don't have any additional occurrences. So what I'm going to do is I'm going to order a $2,500 signature bond for Miss Bailey. And with that signature bond, I am going to order that be through the pretrial services per judge, so that there will be some reporting and accountability on her part. However, she will need a co-signer. Is that correct, pretrial? I think you may have stepped away. Pretrial?
Yes, she will need a cosign.
All right. And so if this aunt, and I don't know if you heard the name, pretrial, Darnetta Stone.
Spell it.
Darneta. And I'm assuming the last name is Stone. Is that correct, Miss?
yes.
Okay. And she will have to bring her ID. And will she need a utility bill with her address?
Unless you waive it, she will.
All right. Do you believe she'll be able to bring that, Miss? Is it Millines?
I'm sure she will. I don't know if her address will match I'm not sure if her driver's license will match the address because she hadn't been there for a year or so, but she should have a bill.
Okay. All right. And so with this signature bond, there's going to be a curfew. And that curfew will be from 9 p.m. to 6 a.m. So Miss Bailey needs to be in the home of Miss Darnetta Stone from 9 p.m. to 6 a.m. She must go to school. finish school or get her GED. She is to have no further contact with you, Miss Malines, and I think it's Millines. No further contact right now. She is to stay away from 755 Jumper Trail in Fairburn. I will allow a one-time sheriff's or law enforcement escort in order for her to return to retrieve her personal items. And so, Ms. Bailey, you're not to go back by yourself. You need to have law enforcement to escort you to get your personal belongings from the home. So you are not to go back there and make that clear. I'm going to order a one-day anger awareness course through pretrial. And I understand there's a referral for an evaluation. And so, Ms. Malines, if you can coordinate with Ms. Stone so that Ms. Stone can get her to that evaluation, I think that's going to be needed, and she is to comply with any treatment that is recommended with that upcoming evaluation. All right, anything else, counsel?
Yes, Your Honor. Did you state it was no further violent contact or no further contact for right now?
I'm sorry, no further contact.
Got it.
Thank you. No further contact.
For how long?
As long as she's on bond. To the end of the case, you can speak to her attorney if there needs to be an amendment. But right now, I think in order that this situation cools down, no further contact with you, okay? All right.
And
I'm
if,
sorry.
I'm sorry, if Miss Malines, if you wouldn't mind chatting me or sending me your phone number in the chat, and I can give you a call after court.
Do you know how to work that feature, Ms. Malines?
I put in a message.
Okay, just send it to
Make
Kaylee
sure,
Wills.
right. Make sure it doesn't go to everyone, specifically scroll and look for her. Specific so that it's a one-way chat. All right, that will conclude this case. Next.
Position 6, Mr. Shanahan.
23 CR 003251Y, Logan Shanahan, charge of 1 count of simple battery, offense date May 22nd, 2023. Pre-trial.
25 total. Last arrest was in 2018, probation. On probation for obstruction, possession of cocaine, crossing state county guard lines with drugs or weapons. 2017, possession of meth, sale of marijuana conviction. 2014, interference with government property conviction. That's it.
All right, state.
Yes, Your Honor. So this incident occurred yesterday at 3000 Hospital Boulevard. And this is where Nurse Kyle Durham, I'm sorry if I mispronounced his name, advised officers that the defendant spit in his face 2 to 3 times after acting belligerent and telling Nurse Kyle that he felt intimidated. Witnesses, there were 2 independent witnesses, one Rebecca Kadayi, I'm sorry if I mispronounced that name, and Andres Gomez advised officers that the defendant was being verbally aggressive toward the hospital staff and that he did spit on Nurse Kyle 2 to 3 times. The defendant told officers that Nurse Kyle spit on him. However, the defendant told officers that Nurse Kyle spit on him and that he was pointing his finger at him. For these reasons, the state's recommendations is a $1,000 surety bond, 1-day anger awareness, no further contact with Nurse Kyle. His last name is spelled Doehrman, and to stay away from 3000 Hospital Boulevard unless the defendant is going for medical care, as well as no alcohol, drugs, or weapons while out on bond.
All right, which hospital is that?
It is, let me get the name of it for you. Just 1 second. Let me pull it back up. 1 second, I'm sorry.
Y'all waiting on me?
No, I was just
Oh.
getting us an answer. PD Wills, you can go ahead and present while she's looking that up.
Thank you. My client is 44 years old. He is currently residentially challenged. I have sent an email over to our social services division. He has resided in the state of Georgia since 1992, and he has obtained some college courses and credits. He does not have any minor children, and he is currently unemployed. At this time, I would request a signature on bond due to my client's limited resources. And if your honor is not so inclined, I would ask for a $500 surety bond in this case.
All right, Miss ASG Bickerstaff.
Yes, the hospital is North Fulton Hospital.
Thank you. I'm going to order the $1,000 surety bond. I'm going to order stay away from 3000 Hospital Boulevard, which is North Fulton Hospital, unless this defendant is receiving treatment. I would almost state that, again, you can't go there if you're going to be abusive or be alleged to be abusive to the employees, but we'll allow that as long as you agree not to be abusive to any of the persons or staff that work there. We're going to order no further contact with Nurse Cal Durham or Dreham. I'm not sure how to pronounce the last name. No drugs, alcohol, weapons, or guns while on bond. And that will conclude this matter.
Position number 10 is next.
Okay.
And we requested a breakout room, Your Honor.
Yes.
How many do we have for breakout today?
Judge Joshua Schiffer on behalf of Miss Cruz. Good afternoon, Your Honor.
Good afternoon.
And I apologize for not being in a shirt and tie. This was not quite my expected afternoon, so I apologize to the court. If I may very briefly, this is a case that I believe the public defender is going to want to talk about mental health issues on. The victim is present. She has her camera off. The victim is a person that is really looking to not share any details with the world about her identity or having the ability of anybody to find her. This appears to be a completely random, unprovoked attack by someone who may have been suffering from a mental breakdown.
Your Honor, that's why we were requesting a breakout room, and I would ask that not be shared on the live stream.
And so, Mr. Schiffer, you're here on behalf of the victim?
Yes, Your Honor.
Okay. Let us go quickly into breakout. If there were others, sometimes we do the breakout cases last, but we'll go ahead and take it now since there are no others. And we will come back or add you in a second. If you don't mind, we'd like to discuss the case first in breakout. And then if we need some more information from you, Mr. Schiffer, I'll add you. As you know, I don't very often have victims who are represented. But let me at least call this case and have pretrial to present before we go into our breakout. 23 CR 00325E, and I do not know how to pronounce the last name. Is it Ubekenwisha? And I know that's terribly wrong. Charged with 1 count of battery, May 22nd, 2023, pretrial on position 10.
14 total. Last arrest was in January. Failed to appear out of cause. He was arrested twice in 2022, contempt of court. 2022 trespass no-lo, and a 2019 disorderly conduct conviction.
All right. All right, we can go into breakout. Is that Miss Johns? I'm sorry, Miss Champion? No. Who's my Zoom person? Oh, Mr. Jordan. I'm sorry.
Who all needs to go in the breakout room?
PD Wills, Vaught, Dip, and Bickerstaff, no?
Yes.
Okay. And myself, obviously. I'm gonna hold on Mr. Schiffer for a second. I may need to add him, but let us go and discuss the particulars and then we'll come back. All right, we're back on the record. And this again is the case with ending in 3253E, which is it Tayson Ubequinisha, and I apologize for mispronouncing the last name. And that's in courtroom 2 or 3? 3. All right.
Judge.
All right, courtroom 3. All right. I have heard the presentation of the case in breakout, and what I'm going to order is a $10,000 surety bond. And with that $10,000 surety bond, there's to be no drugs, alcohol, weapons, or guns in the possession of the defendant while on bond. You are to stay away from 3434 Roswell Road, the church, the gym, all properties there. If you go back there, you will be arrested, Mr. Ubequinisha. So we want to make sure that you, I'm sorry?
She is a female, Your Honor, a woman.
I'm sorry, I apologize, yes. You're to not go back there. If you do, you'll be arrested. So we want to make that very clear. You'll have to make other arrangements. We're also going to order MHET. And so any treatment that's ordered with that, you will have to comply with. I'm going to also order no further contact with the victim in this case. And I'm just sounding for the initials, VDLC. And that means no contact. The bond provisions will state, and we will make sure that all provisions are checked off or included. You to stay 200 yards away or be nowhere around this victim at any time. You're to not contact this victim by phone, mail, email, pager, or any writing, signs, signals, notes, messages. Stay 200 yards away or more. And to also stay away from the 3434 Roswell Road, any of the properties in and around that area. Is that clear, ma'am?
Is, but I'm not quite sure of the terms that you're telling me that of, because you guys had a discussion. This gentleman said some things about me that I found offensive. He's never met me. You're speaking as though I know the victim. I did not know the victim. All I know is that I came out of the shower dressed.
Hold on. This is not your trial. We have allegations with the police report at this point, and I am making sure that you understand the conditions of your bond. And if not, you'll be right back here in the Fulton County Jail if you bond out prior to. However, I want you to understand that you are not to have any contact or not to go around anywhere where this victim may be. Is that clear?
That is clear, but I wouldn't know how to find her. I don't know the person.
Well, that's fine. Just tell me, nope, you will abide by the order. The second requirement of this order is that you not go back to 3434 Roswell Road, to the church or any properties in and around that location. Will you abide by that?
I'm going to need to speak to the pastors of that church. I may be calling them soon.
Well, that wasn't my question. You can't go back there. You can call the pastors possibly on the telephone, but you cannot go back to that location at all while you're on bond.
Okay, I understand that.
Okay, making sure of that. And
this gentleman told me I had mental illness because I hit a naked woman. I don't think so.
well,
I think he's using political propaganda. That's what I think.
Okay, well,
and I find it highly offensive, and I'm going to let you know that I did.
Okay, all right. You're entitled to your opinion, and we're ordering that evaluation. So that will conclude this case.
Position 7 and 8.
Thank you, Mr. Shipper.
Thank you, Your Honor. Thank you, everybody.
Okay. I'm sorry, Deputy, you said 8?
7 and 8.
Oh, 7 and 8. Thank you.
Mr. Smith.
23 CR 003249Y, Willie Smith, charged with 1 count of battery family violence. The offense date is November the 9th, 2019. I will also say on for the second case, 23 CR 0032550Y. You're charged with 1 count of simple battery, the second count of criminal trespass, and that offense date is August the 24th, 2022. Pre-trial.
5th adult arrest. Last arrest was last month, probation in DeKalb. Got an open theft by taking battery DV, trespass, hindering the person from making emergency telephone call. That's in DeKalb County. 2023 speeding, careless driving, resisting arrest, no license conviction, and a 2012 burglary, first offense.
Okay. State.
Yes, Your Honor. So for position 7, the battery family violence, that occurred November 9th, 2019. And this is where officers arrived at 1378 Park Avenue, Apartment B, and they arrived in response to a verbal dispute that turned physical between the defendant and Miss Aria Warren. Aria is ARORIA. And this is where she advised that the defendant punched her in the face, leaving her with a busted lip. The defendant then left the residence after he punched her. The defendant and Miss Warren, they do share a child together. And so for that, the state's recommendation is a $3,000 surety bond, 1 day anger awareness, no further contact with Miss Warren, no alcohol, drugs, or weapons while out on bond. And because they have a child, a third party transfer for the kids. I'm not recommending a stay away because of the second case that Mr. Smith has. I don't believe that either party lives there. And would you like for me to go ahead with position 8?
Yes.
So with that one, the simple battery and criminal trespass, that case occurred on 8/24/2022 at 62 Harwell Road, Northwest Apartment G2. And this is where officers arrived and they spoke with Miss Warren again, who advised that the defendant had smashed her apartment window. And then when she confronted him about that, he grabbed her by her hair and threw her to the ground. Mr. Smith, again, he left the residence after doing those acts to Ms. Warren. So for those reasons, the state's recommendation is a $3,000 surety bond, 1 day anger awareness, no further contact with Ms. Warren, and to stay away from the 62 Harwell Road address, apartment G2, as well as no alcohol, drugs, or weapons while out on bond, and a third party transfer for the children. And if Ms. Warren is on the Zoom call, I would like to sound for her.
All right, Ms. Warren. Aria Warren. All right, don't think she's on the call. All right, PD Wills.
Thank you, Judge. My client is 27 years old. He's originally from Georgia. He does have 4 children, of whom he does provide financial support. He has been incarcerated for the past 2 months, so he has not been working since that time, obviously. However, he was previously employed by staffing agencies doing packing and sorting. One staffing agency, Surge Staffing, he was employed with them for 2 years, and then SS Staffing, he had been employed by them for 6 months, and he believes that upon his release, he will be able to resume his employment. My client does deny the allegations as alleged. He states that the alleged victim slashed his tires. However, he never physically touched or harmed the alleged victim. And I would like the court to take note that these incidents are quite old. The first is from November 9th of 2019. The second is August 24th, 2022. Again, my client has been incarcerated for the past 2 months. I would object to the anger awareness. At this time, he has very limited income and would be unable to pay for that, and I would hate for his bond to be violated for that condition. So if Your Honor would consider a signature on bond, that would be my request. And if Your Honor is not so inclined, I would ask for a bond of no more than 1,000 for each charge, especially given the dates of these incidents. And I did have the opportunity to speak with Ms. Warren. I believe she may have been on, but may have had to leave. But she did state that she does want contact with Mr. Smith, that he does help support her and the children, and that she is not fearful of him.
Okay. All right, I am going to order on the first case, which is the 2019 case. I will order that $3,000 surety bond. I will order no further contact with Aurea Warren. If there is to be any visitation with this child, it would be conducted by third-party transfer. No drugs, alcohol, weapons, or guns while on bond. And then the second case in 2022, I will order a $3,000 surety bond. Stay away from 62 Harwell Road, apartment G2. No drugs, alcohol, weapons, or guns while on bond. And again, no further contact with Ms. Warren. And that's all I order at this time.
On the second case, Your Honor, can you give me the breakdown?
Oh, I'm sorry. 4,000 on, I'm sorry, it's only 3,000. So 2,500 on the simple battery and 500 on the criminal trespass.
Thank you.
Anything else, counsel?
Nothing from the state.
All right. What do we have next, Deputy?
Position 9, Mr. Todd.
This is 23 CR 003252E. Ricardo Todd, charged with 1 count of battery, offense date 11/7/2022, pretrial.
19 total. Last arrest was back in March, probation. On probation in Fulton. Ag assault, a deadly weapon, 22 SC 182485. Possession of a firearm by convicted felon, 22 SC 182495. 2021 driving without a license, possession of marijuana conviction, and a 2012 FTA probation.
Okay. State.
Yes, Your Honor. So this incident occurred November 7th, 2022 at 3804 MLK Junior Drive. And this is where officers arrived in response to an altercation where Miss Ivy Buford asked the defendant to walk the dogs, and then the defendant became upset. And so the defendant grabbed Miss Buford by the neck and pushed her to the ground, and then he snatched her phone from her hands. Officers observed a scratch to her cheek. At the time, the two did live together. Our office was able to contact Ms. Buford, and she let us know that her and the defendant are in a relationship, but they no longer live together, nor do they have children. She stated that she does not recall this incident and that she wants contact with the defendant. And she also let us know that they've been in contact since this incident, and they haven't had any violence between them since this happened. Nevertheless, the state's recommendation is a $3,000 surety bond, 1-day anger awareness course, no further contact with Ms. Buford, and no alcohol, drugs, or weapons while out on bond. I'm not asking for a stay away order, and that Ms. Buford let our office know that neither her or the defendant live at the incident location. And Ms. Buford is on the Zoom call, so I would like to sound for her.
All right, Ms. Buford.
Yes, Your Honor.
Would you like to address the court today?
I would. I just prepared a short statement.
All right, let me swear you in. Raise your right hand. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right. Would you like to state?
I am the girlfriend of Ricardo Todd. Firstly, I'd like to say that he and I have resolved any issues we were both facing during a really difficult time in both of our lives. I don't believe the reports are entirely incorrect, but I do think the details are highly embellished. I have since attended and completed courses on anger management, as well as resumed my routine therapy visits for my own personal reasons. And again, we both navigated, which was a very challenging time for both of us back in 2022 in regards to this situation. And that's all.
Are you in fear of Mr. Todd?
I am not.
Do you want to have contact with him?
I do.
Okay. All right. Any cross-examination, ASG Bickerstaff?
Nothing from the state, Your Honor.
Any cross-examination, Ms. McLeod?
No, Your Honor.
All right. All right, you can mute yourself, Ms. Buford. Thank you for your time. All right, Ms. McLeod?
Yes, Your Honor. My client is 35 years old. He's a native of Atlanta. He tells me that at the moment he is unemployed and has been unemployed for a few months now, although he's looking for work. I do understand that my client does have some history, Your Honor, but this incident between himself and Miss Buford happened last year. I believe the warrant said the 22nd of November. And she has stated that they have been in contact since then. My client says the same thing. They do not live together. There is no need for cooling down period since they obviously have long cooled off and this incident is behind them. I would ask the court to give my client a very low bond because I imagine the court would not be inclined to give him a signature bond, but he doesn't have $3,000 to pay to get out, Your Honor. He has no money to pay for bond. I would ask the court to take that into consideration in setting the bond, and any condition concerning Miss Buford should be no further violent contact. Nothing further, Your Honor.
All right. I'm going to order the $3,000 surety bond. I am going to order, due to the dates of these offenses, no further violent contact with Miss Buford. And I'm not for sure who resides at 3804 MLK. Do either of the parties reside there?
Your Honor, neither lives there.
Okay. All right. So, but I will not do a stay away, but in ordering the no further violent contact, I want to make sure with Mr. Todd that we don't have any other incidences. So I'm going to order him to take a 1-day anger awareness course. No drugs, alcohol, weapons, or guns while on bond. And I think that will be the order of the court. Anything else, counsel, that I failed to address?
No, Your Honor.
All right. Thank you.
Thank you, Your Honor. That concludes my business before the court today. May I be excused?
Yes, you may. See you later.
Thank you.
Mm-hmm. All right.
Position 11, Mr. Walker.
Okay. This is 23 CR 003259F. And again, we have Mr. Giovanna Walker. He's charged with 1 count of driving, hit and run, improper erratic lane change, driving expired or no license plate or decal, possession of marijuana less than an ounce, and DUI under the influence of drugs. Those are 5 charges. The offense date is May 22nd, 2023. Pre-trial.
24 total. he got 2 arrests out of 2018, driving without a valid license conviction. 2012 robbery conviction. 2011 resisting. Possession of a firearm by convicted felon conviction. That's it.
All right, state.
Yes, Your Honor. So this incident occurred yesterday on Interstate 7585. And the state, we had limited information about this case, but in the warrants did state that the officers cited the defendant for failing to maintain a lane, and that's where he got into a car accident with another driver, and the defendant failed to immediately stop or remain on the scene of the accident to render assistance. The officer cited the defendant for driving under the influence of marijuana or THC. The officer also cited the defendant for not having a valid tag decal on his license plate. And he also cited the defendant for possession of an ounce or less than an ounce of marijuana. The bond for the defendant was set to $5,000 for these charges at $1,000 each for each charge. And so the state is going to keep that bond at $5,000, $5,000 surety bond and $1,000 for each charge, as well as no driving unless DDS approves, as well as no alcohol, drugs, or weapons while out on bond.
All right, PD Wills.
Thank you, Judge. My client is 37 years old. As was stated, he has very limited history and most of it is quite old. He does have family and a support system here. He has a high school diploma, does not have any children. He was previously employed by Enviromedics as a delivery driver. My client states that he suffers from seizures, and he believes that he had a seizure when he was driving on this night. And that he actually blacked out and did not remember the accident or anything. When he came to, he was arrested. So he definitely did not have the intent, and he denies using any illegal substances. We would request that the bond be lowered to $2,000 surety bond if Your Honor is so inclined.
I'm going to leave the bond at $5,000, $1,000 on each of the charges, $5,000 surety bond. No driving unless you have a valid license from DDS. No drugs, alcohol, weapons, or guns while on bond. And I believe that's it. Anything else, counsel?
That's all from the state.
And Your Honor, my client has very limited income, and he states that he is unable to afford the $5,000 bond. And Mr. Walker, I see your hand, but I would recommend that you advise that you exercise your right to remain silent.
I don't see that, or do we have any other medical information that that's what happened? I mean, those are all probably issues for trial. But it does have some substantial history.
Your Honor, I have a history of it. And with this situation, I really have no clue about everything.
Mr. Walker, please.
But, Your Honor, what I'm saying, why I'm saying what I'm saying is because in order for me to get that history, that report, I need to be home. In order for me to maintain whatever needs necessary, I need to be out because I'm about to lose everything due to something that's just a part of my life that I didn't make, but this is just, I don't know, you know what I'm saying? I'm new to it.
Right, I do understand. However, there was an accident and you have some prior history that is concerning to me, as well as the no driver's license conviction in the past as well. So, what I can do is possibly lower it to a $4,000. And then what I can do is on the possession of marijuana, less than an ounce, I can make that a $500 signature bond through the jail, and then $1,000 on the other 4 charges to make it a $4,000 split bond, $4,000 on the other charges, and a $500 SOB jail on the marijuana. All right, is that clear, Miss Champion?
So it'll be a total of a $4,500 split bond, correct?
Yes,
Okay.
4,500 split. Thank you. All right. That'll conclude this case. Is that it, Deputy? Or we have one more. All right, no, what happened to position 2?
Position 2 waive his appearance.
Oh, okay. All right.
Position 2, he spoke with Miss McLeod.
Uh-oh. And she left us, didn't she? I think she thought her business was concluded.
So
I thought you emailed Miss Will saying that Mr. Dixon didn't need a conflict.
I did, but then when I tried to speak with him, he had already spoken with Miss McLeod and he was taken back. So I was unable to speak with him. And so Mr. Howard just advised that we just let it remain as was. But it wasn't a true conflict. I believe he's in on some very serious charges. And so that actually, I'm not sure how that would work for her today since she already spoke with him. But he wasn't a conflict. If our office could pick the case back up and I can represent him tomorrow. I'm just not sure how that works.
Okay. We can reset him to tomorrow.
And Judge, are we able to recall Bailey?
Thank you. Hey, Judge, Ms. McLeod is gonna come back on.
Oh, she's coming? Okay.
Yes.
Let's put him back in the chair then. Well, let's see, while we're waiting on her to sign back on, you want to pick back up on case number 1, which is Bailey?
Yes.
All right. What's the issue there?
Your Honor, so our office spoke with Miss Bailey's aunt, Miss Stone, and she stated that she's not in agreement with the defendant staying with her while she's out on bond. So we need to figure something else out.
Well, I'm certainly not going to allow her to go back home yet. This just happened less than 24 hours. I am concerned about the alleged actions. And I want to make sure that we don't have any more victims and no more confrontations and no more fighting and no more allegations. And so I don't like to have people to go back to that environment in less than 24 hours. We've ordered the evaluations. They're probably going to order some forms of treatment, maybe medication, I don't know. And so again, there needs to be somewhere else where this defendant can go in the meantime until we can get some systems and things in place to assist her.
So my only concern was on the weekend. I worked 12-hour shifts. So basically for 3 days in a row straight, I'm gone. I'm not at home. So that was my only concern, is her being at my home by herself. But
okay, hold on a second. You are?
I'm her aunt.
Your name?
Darnita Stone.
All right. And so she's 17. She's not 7. So I'm not sure the concern of her being at your home on the weekend, as long as she's there and she's not at her mother's home, she's not violating her bond.
Okay. My concerns is not her age, is what she'll do in my house.
Well, I can't order somebody to stay somewhere Monday through Friday and somewhere else on the weekend because you don't want her home alone. But I understood that you sign her bond. If not, I'm going to have to turn it into a surety bond and she'll just have to stay in jail until she bonds out. If there's no one that's willing to sign for her on a signature bond, because she is 17, she has to have a co-signer.
Okay. And my other question was, where do I come to sign, to co-sign for her?
Come to the Fulton County Jail, to the pretrial trailer. They'll direct you to where that is.
Okay.
I'll write it in the chat.
All right. Are you able to see the chat?
I be forgetting how to get to the chat.
Y'all got pen and paper?
He'll tell you real quick.
Okay, once.
Or,
I grab my phone.
hold on, I don't know why I feel like an old person. I can't work the doggone thing.
No, if you're not used to it, it's no issue. We understand. I think he's going to tell you if you get a pen and paper real quick.
What was that? The last name was Stone, right?
Yes, Stone, Darnetta Stone. All right, you ready for the address? Okay.
1101 Jefferson Street, Atlanta 30318. When you get to the guard shack, tell them you're here to co-sign for your niece and they'll let you in. It's a pretrial trailer. It'll be in the parking lot to the right once you go through the guard shack. Take your ID. Judge, what you doing about the bill, the utility bill?
Yeah, let me ask Ms. Stone real quick. Do you have a utility bill for the address where you reside, Ms. Stone? Can you unmute yourself?
Sorry.
Does she have a utility bill?
I do.
Okay. All right, bring that utility bill with your ID to the trailer that pretrial just described.
Judge, I don't know if she was on earlier about this curfew thing.
Oh, yes. Did you hear about the curfew as well? Did she tell you from 9 p.m. to 6 a.m.? Ms. Bailey must remain in the house? Because
Okay.
if she's found out or if she's arrested or out somewhere and violating curfew, that will send her back to jail as well.
And no drugs, no weed, no
No
alcohol.
drugs, no alcohol, no weed, no weapons, no guns while on bond.
And Your Honor, we just wait for a court date? Is that
Yes,
bond is like until she goes back to court?
correct. You'll be in contact with PD Wills. This is your case, correct?
Mhm.
Yes, you'll be in contact with her, and she will let you know when her next court date is scheduled for.
Well, I'm only handling her case for the purpose of bond. So
Oh, they don't qualify otherwise. Okay. Make sure then that your address or the address where she's staying is updated in the court records, because they will mail the notice there unless you get an attorney in the meantime. Then that attorney can enter an appearance and be the contact for the case. But right now it is Miss Stone, I'm sorry. So Miss Stone's address will be the address where the notices will be mailed to.
Okay.
Yes, and Your Honor, our
Yes.
victim advocate, our office will be in contact with her as well.
Okay.
Yeah.
Right. The solicitor's office will be in contact with Miss Stone. I'm sorry, Miss Malines.
The mother?
Yes, because you're the victim in the case, Miss Malines. So they will be in contact with you as far as a court date as well.
With the 1 day of anger management, is that done through the court, or will she have to seek outside like her own?
No, that is done through the pretrial office. They will give you that information as well. Correct, Mr. Howard?
They'll let her know. They'll let the defendant know
Right.
when she gets released. When she goes to orientation. It's on Zoom.
Okay.
Okay. All right. That will conclude the case. You can sign off, Miss Malines.
All right, thank you.
Thank you.
Now, when you co-sign, it's gonna be a while before she get out. So she's not gonna walk right out the door. But the process doesn't start until you co-sign.
Okay.
All right.
All right. Thank you. All right, Miss Champion.
We still have position 2.
I'm sorry.
Position 2.
Did we say we were reset? Oh, I'm sorry. Yes, Miss McLeod came back. Thank you.
Your
Glad we
Honor.
were able to catch you. Yes, position 2. 23 CR 003255J, DeMarcus Dixon, one charge of 1 count of battery, April the 19th, 2023. Pre-trial, I'm sorry.
He got 19 total.
Okay.
He been in jail since last year, if I'm not mistaken. He was convicted for cruelty in the first, ag assault, terroristic threat, possession of a knife or a firearm during the commission, aggravated battery. 2019 simple assault, 2014, 15, and 17 probation, and a 2014 disorderly conduct conviction. That's it.
Okay. State?
Yes, Your Honor. So this incident occurred April 19th, 2023 at 185 Central Avenue. This incident occurred in the jail, and this is where the defendant head-butted Mr. Leroy Pitts. Mr. Pitts' head struck the door frame, causing a laceration above his left eye. Your Honor, the state's recommendation is a $4,000 signature bond to be released to the jail because the defendant is already currently in custody, and as well as no further contact with Mr. Leroy Pitts, Your Honor. And if we could, yes. That's all from the state.
Okay.
Your Honor, I'm not
Yes.
sure.
Go ahead.
What pretrial has stated in terms of my client's history is accurate, because I believe he's only 20 years old, and I heard something about 2014. But I could be wrong, but I was under the impression my client was only 20 years old.
Oh, State, give your history, please.
Yeah, I have a 2014 PV in Baldwin. This was not my case. This was actually Deputy Fox's case, but according to the notes right quick, but let me look it up in the, our system. Just give me 1 second.
Okay.
I was under the impression he was born in 2003, but I could be
Who told
wrong.
you that? Who told you that?
I have 93. Is it 93?
That's really sound more accurate, but let me look.
Yes, I have 93 as well.
That would make him, he would have been 21 at that time, so.
Yeah,
Okay.
McLeod, don't come on here confusing everybody.
I was totally 20 years old. Okay.
She can do her math. She just wanted to make sure. I get it. All right. So I think that is correct. That first one would have been at 21.
Your Honor, he has been in jail for, I believe, over a year. My understanding is that he has been convicted and is going to be going away to prison. Of course, he's not in a position to post bond, and even if he could, he's not going to get out. He's not going to get out of custody. But what he tells me was that this was something that was provoked, and he was merely defending himself against this other inmate, Your Honor.
Okay. Well, the state has recommended a $4,000 signature bond through the jail.
Yes, to be released to the prison, Your Honor. I'm sorry.
Right.
Mhm.
Do we know what prison?
No, Your Honor.
You don't? Okay.
But if we
Sure.
could place this on the SAP calendar for May 30th, and we could address it then.
Ms. Champion?
If we can.
Yes, ma'am.
Did you hear ASG Bickerstaff's request?
I'm sorry, what was her request?
If we could place this case on May 30th SAP calendar.
Does he already have a case on that calendar or something? What's the reason?
I'm not sure. Deputy Falk just sent me
He's
a
going to
note.
prison, so she's trying to handle the case before he goes down the road.
Okay, that's all I need to know.
Okay.
Thank you. All right, so this is a $4,000 signature bond through the jail, but to be released to the prison. And if not, just so that we can keep up with the case, it will, if he has not already been picked up by the agency that is going to be housing him for his incarceration, then it will be placed on the May 30th SAP calendar.
So we couldn't.
So we can keep up with him and make sure what has happened with his release.
Thank you, Your Honor.
All right, that should conclude this case if there's nothing else. And then we'll reconcile in a minute.
That's all from the state.
All right, thank you. Thank you, Ms. McLeod.
You're welcome, Your Honor.
All right.
Position number 1 is a $2,500 pretrial bond per judge reset further notice. Position number 2 is a $4,000 sign-on bond through the jail. It's going to be reset to the May 30th SAP. Position number 3 is a $3,000 good bond reset SAP June 6th. Position number 4 is a $3,000 pretrial bond reset further notice per judge. Position number 5 is a $20,000 good bond reset SAP June 6th. Position number 6 is a $1,000 good bond reset SAP June 6th. Position number 7 is a $3,000 good bond reset SAP June 6th. Position number 8 is a $3,000 good bond total reset SAP June 6th. Position number 9 is a $3,000 good bond reset SAP June 6th. Position number 10 is a $10,000 good bond reset SAP June 6th. And position number 11 is a total of a $4,500 split bond reset SAP June 6th.
Okay, that looks good to me. Anyone else, any corrections or questions? All right, we will see everyone next time. Thank you.
Thank you.
All right, bye-bye.